section, we will look at redundancy dismissals, duty to consult, and redundancy related payments. Let's start with what is redundancy. This is going to be the most common form of dismissal, and a huge amount of future litigation will be around redundancy, followed by discrimination complaints. The coronavirus job retention scheme is designed to support employers whose operations have been severely affected by coronavirus in allowing them to retain employees on a furloughed basis for a defined period of time. It is unfortunate, however, that even with support measures such as the furlough scheme in place, the coronavirus situation may result in some businesses having to cease trading or reduce the size of their workforce through redundancy. In these circumstances, the normal legal provisions regarding redundancy continue to apply, and it is essential that employers carefully plan and prepare for handling redundancies, given the sensitivity of the issue and personal impact on employees and their families. The legal definition of redundancy identifies three sets of circumstances in which an individual can not be employed anymore. Number one is business closure. The business is closed, ceases to trade altogether. Workplace closure, that is closure of one of a number of sites or relocation to a new site. So the whole business would not close, but it may close one of its shops, for example. Diminished requirements of the business for employees to do work of a particular kind. For example, the company brings in software instead of physical filing. Bookkeeping, for example, or accountancy issues where company says, well, we are going to use software or record keeping or time management, for example. In that case, it means there is no more requirement of an employee doing work physically or adding records or receipts or invoices manually. Redundancy is likely to be because your employer does not need as many employees to do the work that you do, or where the workplace is permanently closing down. If an employee's dismissal takes place in such circumstances, it can be said that their dismissal is by reason of redundancy. It is a different question whether that dismissal is fair or unfair. One of the above situations will be more likely as a result of the COVID-19 situation, and in the aftermath of the situation, while the world is trying to deal with the consequences, financial and economic consequences, it is likely that these situations will arise and there will still be dismissals. Unlike furloughing, layoff, or short-time working, redundancy ends your employment. Your employment is simply terminated. As an employee, it is still possible that you may be made redundant while you are furloughed. Let's look at our next video, which will explain duty to consult. This is obligation on the employer to consult with the employee whose job is at risk of redundancy. See you in the next video.